Okay, we'll go ahead and get started again. If you want to grab a soda or some fruit, some bars, got coffee still and water, grab some refreshments and head back to your table. We'll start our session on the state issues. And I'm going to go ahead and introduce both of our speakers at once and let them just kind of tag team. We'll start with Matt. But you know, as local elected officials, we make decisions on policies from a broad range of issues and topics, but none of us are experts in everything. And I know when I started as commissioner here in Mesa County in 2005, my background was in psychology and counseling and communication. And I wasn't a petroleum engineer or a chemical engineer, and I knew very little about the energy industry, and yet was faced with an energy boom happening in our community. I was fortunate to have Craig Meese on our board, who's a chemical engineer with about 18 years experience at the time in the industry and the compliance piece of it. So he would sit next to me and explain, you know, this issue that's being raised is legitimate, and here's how you mitigate it. This issue isn't factual, and here's the science behind it. Here's the history about how this happened, and we need to make sure it never happens again. But not everybody has a chemical engineer on their board of commissioners. So that was the purpose and the focus and the goal behind these types of symposiums and the work that we're doing here at the Center for Local Government. So I'm hoping you're enjoying all the speakers and all the information you're getting. Our first speaker will be Matt Lepore. He's the director of the Colorado Oil and Gas Conservation Commission. He graduated earning a bachelor's degree from the University of Colorado Boulder in 1987 and earned a JD from Stanford University in 93. Prior to his position at the COGCC, Matt served as the Colorado Assistant Attorney General and was counsel to the Oil and Gas Conservation Commission. He counseled the commission concerning interpretation and application of the Oil and Gas Conservation Act and the commission's implementing and regulations. Matt also assisted the commission in administrative enforcement, adjudicatory matters, and agency rulemaking. Prior to his tenure with the Attorney General's office, Matt was a partner in a large Denver-based regional private practice, and there he provided environmental compliance counseling and liability risk assessment for business and property transactions. His publications include Fundamentals of Drilling and Spacing Units and Statutory Pooling, the Nuts and Bolts of Mineral Title Examination Special Institute. Smart guy, huh? Legislating carbon sequestration, poor space ownership, and other policy considerations, and my personal favorite, nanotechnology and human health. We don't know nano. And I don't know nano, so I'm glad you're here. Straighten us out. Our other guest we're pleased to have from Utah is Dr. John Baza. He's the Utah Division of Oil and Gas and Mining Executive Director. He's a petroleum engineer holding both Master of Science and Bachelor of Science degrees in petroleum engineering from Stanford University. His career spans over 33 years working with the energy and mineral extractive industries, and his experience includes engineering positions with several major and independent petroleum companies, including Phillips Petroleum, Amoco Production Company, and Flying J Oil and Gas. He's been involved in the petroleum and exploration and development in Wyoming, North Dakota, and Utah, and he has also worked on geothermal power projects in Utah, Nevada, and California. This piece was new to me until I got his bio, that in early January of 2010, he was appointed to fill a vacancy on the 5-member city council for the community of West Bountiful, Utah, where he lives and resides, and he served in that capacity for 2 years. So he has a lot of experience in the energy industry and the regulatory environment of it, but also as a local elected official. So please welcome me in joining first Matt and then Dr. Baza.
Thank you very much, Janet. Good morning, everybody. It's a pleasure to be here. I really appreciate the opportunity. I want to thank the sponsors, Colorado Mesa University, Garfield County, and West Slope Koga, for asking me. We'll see if I'm smart enough to work the machine. I was asked to talk today about the interplay between the state and local governments with respect to regulating oil and gas. So my focus will be somewhat narrow, and I'll try to give you a little a rundown on that. Before I start, too, I want to introduce 2 members of my staff who are here just so you can put names with faces. About a year ago, as part of the effort to improve communication and relation between state and local governments, we hired 2 new positions called local government liaisons. And those 2 members of my staff are dedicated to working with local governments, again, to facilitate that communication. So Mark Morton is there. Mark covers the west slope. And right on cue, Nancy Prince just walked in the door there. And Nancy is the other LGL, and she covers the east slope. And they have just been doing a great job since they came on board in their outreach to all of the local governments across the state. So before I dive into the nuts and bolts, I really like this quote from the Groundwater Protection Council. In my view, so much of what is happening, particularly up and down the Front Range, maybe to a slightly lesser extent here on the western slope, in counties like Garfield and Moffett and Jackson that have seen a little bit more development historically, there is this upset that happens when oil and gas moves into an area either for the first time or perhaps what we're seeing on the western slope is when there's a dramatic change in the sort of nature and scope of that oil and gas development. But as many of you certainly realize, oil and gas is not new to Colorado. Colorado actually drilled one of the first commercial wells in the United States way back in 1864 in the Florence field. But as one of Rebecca's slides alluded to, in Front Range communities like Longmont, Erie, Colorado Springs, Boulder, you've seen a lot of concern from citizens and a variety of responses from local governments reacting to that concern. And we'll kind of talk a little bit about that. What is COGC's role and where do we get our authority and you know, how does this work? The General Assembly has declared it to be in the public interest to foster the responsible and balanced development and use of our oil and gas resources. And they've directed us, the Commission, to do that in a way that protects public health, safety, welfare, and the environment. That's really kind of a mouthful. And if you think about that from a policy or political point of view, that is a big mission. And a lot of attention gets focused on that mission. Is one agency capable of both regulating, being the enforcer, and protecting the environment? My answer is absolutely yes. And our agency takes both of those roles incredibly seriously. And we have on staff something like 18 dedicated environmental protection specialists to carry out that environmental protection role. So we're a creature of statute, right? The Oil and Gas Commission exists because there is a statute, the Oil and Gas Conservation Act, that created a commission and creates a statutory framework for development of oil and gas in the state. And in addition to that first part that was on the first slide, we're charged with ensuring the exploration and production of the resource happens efficiently, that we prevent waste, and that we protect correlative rights. So I need to pause here and tell you what I think promoting or fostering development means. And I want to talk about waste and correlative rights too. And a good way to do it is in reference to this picture. That's what oil and gas development looked like in the first part of this century when commercial oil and gas development was really taking off. There are similar pictures from other fields across the country, Pennsylvania, even in Colorado. So what's going on in this picture and why? So one thing that's going on is I promise you there are a lot more wells that need to be there to drain the resource, all right? So that's economic waste, right? There is way more capital being invested right there than is necessary. Interestingly, that's not the most efficient way to get the resource out of the ground. Even with all those wells, what's going to happen is you're going to drain some of the resources right in that immediate vicinity of the wells and lose the opportunity to get resources out from the perimeter because you've eliminated the pressure from the field. So it actually leads to what we call waste, that is leaving the resources in the ground, all right? So why does this come about? This comes about from something called the rule of capture. And it's a fundamental principle, and it's a good principle for you to understand. Rule of capture is a legal concept that came out of a court decision in Pennsylvania, again, around I forget the exact date, early 1900s, that said this. It said, if you put a well on your land and you recover minerals, you're entitled to keep the minerals that you recover from that well, regardless of where the minerals come from. So you can get your neighbor's minerals and keep them as long as the well is on your land. Does that kind of make sense? Can you picture that? So I'm going to put my well where? Right on the boundary of my land, right? Right in the corner if I can, so that my well gets as much of your minerals as I can. Now, what are you going to do if you have minerals? You're going to put a well right on the other side, right? And that pattern just repeats itself over and over again, and that's what you see here. So what you see here are different parcels of property with different surface and mineral ownership, and everybody putting a well on their land to capture their minerals. That's the only way they could protect their minerals. This is actually why oil and gas conservation commissions came into being. Oil and gas conservation commissions came into being as an exercise of state, or in some cases local, power to say, wait a minute, this makes no sense, and we're going to regulate this. And what we're going to do are create spacing areas and pool the minerals in those spacing areas so that we could do maybe one well in that area that you see and drain the resource efficiently and have every of those mineral owners share proportionately in the resource. So in my mind, when we talk about the Commission's duty or obligation to promote efficient production of the resource, we're talking about this. I don't have a marketing budget for the oil and gas industry. I am not a cheerleader for the oil and gas industry. I want us to produce our resources in Colorado for the reasons the General Assembly said, right? It's in the public interest to do so. Otherwise, I don't care what the industry does. I am charged with regulating them and protecting the environment. So I think this is just an important sort of framework to have in mind. We have broad jurisdiction. I love our jurisdictional statement. It says that we can do whatever is reasonably necessary to carry out the provisions of the Act. That is a broad statement. I mean, I can tell you as a practicing lawyer for about 20 years, that's about as good as it gets. And then we have a whole bunch of specific authorities underneath that says we can require drilling permits and things like that. We can regulate gas storage fields and so forth. But overarching is this very broad statement of authority and of jurisdiction. So the Oil and Gas Commission was created in 1951. That's when the Oil and Gas Act was adopted, and so we've been around for 60 years. And I think that's important to think about too. Our first set of rules was published in 1952. So we have a body of rules that has evolved over 60 years. And as Rebecca mentioned in her talk, it's very much a living process. We adopted major rule changes in 2008 that went into effect in 2009. In 2011, we adopted this frac disclosure rule, and this year we adopted rules on groundwater monitoring and on setbacks and public notice and communication and so forth. So the rules evolve, they have evolved for 60 years, and they evolve to keep up both with technological changes and, quite frankly, with social changes as well. We have a staff of 76 people right now. The General Assembly gave us the budget to add 19 more people to that staff this year, for which I thank you. We're going to put a lot of them as inspectors in the field. There was a lot of concern. I'm sure many of you are aware. We get asked a lot about how many inspectors we have. Colorado has 50,000 active wells right now. And a lot of people want to know how many people we have inspecting those wells. So right now the answer is 16. A lot of people don't think that's enough. The General Assembly, I think, was in general agreement that that was not enough. And so about 11-ish of those 19 new staff will be part of the field inspection group. Some of them will be part of the environmental protection specialists so they can support that inspection group and so forth. As the General Assembly, I think, very much understood the concept that, yes, you can give us a whole bunch of inspectors, but then we need those people in the engineering group and the environmental group and the enforcement group to support them when they go out into the field. So there's a lot of experience here. We have PhDs, we have people with masters, we have people that have been part of environmental consulting firms for many years. And I'm just going to tell you that I think that makes us different than any local government, right? We have more experience, more staff that know about oil and gas operations than any local government can bring to bear on this issue. And I think that's important, and I don't mean it in a critical way, I just think it's a fact. And it's a reason why you do have state agencies at the administrative level dedicated to these fields of expertise. That is the point of having a state administrative agency. Okay, so on to the real topic at hand. It's just not a disputed question whether local governments have authority to regulate some aspects of oil and gas. They do. You do. You county commissioners that are in the room have authority over oil and gas to some extent. The question is, and again, I liked the way Rebecca referred to it, I love the idea that the ideal is cooperation, right? Harmonious regulation, but sometimes the reality is, maybe a little bit more contentious than that. Actually, I think we are forging great relationships with most of the local governments that we deal with, that are engaged in this process, and that have an interest in this process. We're not batting 1,000, but we're doing well, and we're getting better. But let's just make sure everybody understands that we don't think we're the only game in town. Local governments have a role. There are questions about where my role starts and stops and where your role starts and stops, and there are probably overlaps. So we start to get into the legal fine points a little bit. There are a series of cases. The body of case law around this question is actually pretty finite, and I'll show you a list of those cases in just a second. But sort of the threshold issue is always going to be, is what is being regulated a matter of state concern or local concern? And sometimes it can be a mixed state and local question. So the formula is pretty simple. If it's a matter of state concern, the state gets regulatory primacy. If it's a matter of local concern, the local gets regulatory primacy. So if it's a matter of local concern, let's say roads is a kind of a classic one, and local government wants to have a rule about roads, and the state has a different rule, the locals win, all right? And then we get to these mixed questions, and in mixed questions, we have to harmonize the regulations. So we can have both state and local regulations as long as there is not an operational conflict. The trick is that deciding whether there's an operational conflict is about as clear as mud, okay? It's the difference between a rule and a standard. So for those of you that traveled from out of town here like I did along I-70, there are speed limit signs along the way. Speed limit 65 miles an hour. I know how fast I am supposed to go. I know if I'm going 66, I have violated that rule and I could be in trouble. What if the speed limit said, please drive at a safe speed considering all of the circumstances present at the time? How fast would we all be allowed to drive? Some people would be going 40, some people would be going 120, and we'd all have an argument that we were obeying the speed limit, right? That's kind of how I see operational conflict. And the courts have made it clear that if we're going to have a conversation about operational conflict, it has to be on a fully developed factual record. So it is a fact-intensive, case-by-case, ad hoc determination. a model of inefficiency. Great for lawyers, great for the judiciary, not so good for the courts. And that's, we see that played out in these conversations with local governments about, can I do this? Can I regulate that? How far can I push this regulation before it becomes an operational conflict? And there is no clear line. So in the Longmont lawsuit that Rebecca alluded to and that I assume many of you know about, Longmont adopted a regulation, local regulation, that bans fracking in its city limits. I'm sorry, that's not correct. In its residential zoning parts of its city and in its planned residential zoning parts. We think that goes too far, right? We think there's case law that says a city doesn't have that authority, that well spacing and location is our jurisdiction. My bet is that will go to the Supreme Court, unless there's some other resolution beforehand, because it will just we'll have to do a lot of factual analysis and then it'll keep going up and up and up. So that's the beauty of operational conflict. So very general before I get into the nitty-gritty. If it's a technical part of drilling, it's almost certainly state interest and therefore our regulation. So a lot of times you'll hear the term downhole. Is it a downhole issue? Local jurisdictions don't generally think that they have authority over downhole. If it's a land use issue, it's a local issue. But again, what's the boundary between land use and technical? And that's where these conflicts, to the extent there are conflicts, are arising. Good, you can actually read the green. So as I said, it's a fairly finite body of case law, a couple of Supreme Court decisions back in 1992 that are really the seminal cases, and then a handful of cases since then in which the lack of clarity about what is operational conflict, some of those issues have been worked out. So Bowen Edwards involved La Plata County, some regulations that they adopted over oil and gas. The key issue there was whether or not the Oil and Gas Act, our statutory authority, preempted all local regulations over oil and gas. Unequivocal answer is no, it does not. However, as I've already said, local regulations can be preempted by operational conflict, where effectuation of a local interest would materially impede or destroy the state interest, whatever that means. The first bullet there just says what I've already told you, that if it's a downhole technical issue, it's the state's interest. The second bullet is why we're having a lawsuit with Longmont, right? The Supreme Court in this Bowen Edwards case said that oil and gas production is closely tied to well location, and that goes back to that slide of Spindletop, Texas, right? Regulating where we put the wells is important to the production of the resource. And in 1992, the Colorado Supreme Court said that, therefore, is a matter of state interest over which COGCC has regulatory authority. The next Supreme Court case came out of Greeley. Back in the late 80s, early 90s, the city of Greeley, now think about this for those of you that know what's going on in Weld County and Greeley right now. Greeley wanted to ban drilling and did adopt a regulation banning drilling in its city limits. That case worked its way up to the Supreme Court, and the Supreme Court said, first of all, we have to decide whether drilling is a matter of local or state concern. To do that, it said we're going to look at 4 issues. The 4 issues are, is there a need for statewide uniformity? Do we want the state to all have the same set of regulations? If the locals regulate this, will it have extraterritorial impact? In other words, if Greeley bans drilling, what happens to the surrounding jurisdictions? If Weld County bans drilling, never happened, what happens to Boulder County? They celebrate. Next issue is, has state or local government traditionally regulated in this subject matter? And the fourth issue is, what does the Colorado Constitution say? Oh, my slide got transposed a little bit. You'll have to move those arrows just to the left a little bit. So here's how the court analyzed those four issues. Three of them it found went in the state's favor. So those first three factors, it said, those are matters of state concern. The constitutional issue was sort of a toss-up. Therefore, the court held a home rule city may not totally exclude drilling operations within its city limits. And that's the state of the law today. So let's go back to Longmont real quickly. Does that mean a city cannot ban drilling in its residentially zoned parts of its city? Well, the state chose to sue, so you know what the state's lawyers think. But not here to say it's a slam dunk. I mean, this Greeley case did not decide that question. So that's why we continue to need to work these things out, and go into court's one way to work them out. I'm going to kind of go through these a little bit quickly. If you want to, get down into the weeds, I'm happy to talk with you about it at any time. But these are just a series of subsequent cases that have entered rulings on specific issues. So in this particular case, Town of Frederick versus Narco, on a motion for summary judgment, the court held that a number of local regulations dealing with these issues were preempted. So setbacks greater than COGCC. So, local jurisdictions, there's been a lot of question about setbacks. Can we make our setbacks 1,000 feet? The state, I hope you know, just adopted new setback regulations that have sort of a 500-foot hard setback and then a 1,000-foot zone where all kinds of mitigation measures are required. What if a jurisdiction wants to go 1,200 feet? We would make the argument that that's preempted based on this case. And then we would make similar arguments with respect to these other issues. You're going to get to hear from the Gunnison County Attorney and LGD later this afternoon. Gunnison has been pretty active in this area going back for many years. There are 2 lawsuits that have made part of this body of law that Gunnison has been a party to. And again, just fundamentally the court working out specific issues here that the county may not impose fines inconsistent with our regulations, and they may not impose record-keeping requirements different from our regulations. Also, again, that technical aspect being considered the state's domain. In that same case, though, the court said there are a whole bunch of issues that we cannot decide without an evidentiary hearing, and so, in other words, these things are open to that operational conflict analysis. And that included wildlife issues, water quality issues, drainage erosion control, et cetera, as they're listed there. The court also held that there is no such thing as same subject preemption. So just because we have a rule on wildlife doesn't automatically mean a local government might not also be able to have a wildlife rule. Again, it's going to come down to that. Can we harmonize those rules or not? SG interest, Gunnison County, again, this is ongoing litigation. David may or may not talk about it. I have not kept up to the minute on this, but that court did hold that the county could not require an operator to pay a third-party expert to review reports for it. And then it held that there were many other provisions that required an evidentiary hearing. And these are 2 of the most recent cases. A local jurisdiction cannot impose fees on active oil and gas sites for site safety and security reasons. So in Milliken had their police department going around and inspecting oil and gas locations, and it kind of looked like that same sort of security check they do at every other business in the jurisdiction. Is the gate locked? Is anybody trespassing? Are the lights working? And Milliken wanted to impose a fee on the operators to do that, just oil and gas operators. Court said that's not going to fly. and the KP Kaufman case was somewhat similar. That Milliken, I think both of those have now been decided by the Court of Appeals. Milliken was just decided this last week, May 9th. So this is a bullet point summary of what I would say the state of the law is, and I'm willing to say that, you know, the speakers this afternoon might not agree with me on every single jot and tittle. But I think based on the body of case law that I've just walked you through, local governments could not ban drilling completely. They cannot regulate the technical aspects of drilling. Local governments cannot regulate well spacing, which gets into the setback issue. Can't impose fines that are inconsistent with ours. Can't require record-keeping obligations different than ours, and cannot impose requirements more restrictive than ours. There's no question that a local government can require a special use permit, charge an application fee, and regulate roads and emergency response. And I think there's an open question on a significant number of issues around water quality, water body setbacks, and some of the other issues listed there. So maybe the most important slide, as far as I'm concerned, you know what? I don't really want to usurp your local land use authority. I don't know anything about it. It's not my area of expertise. It's not why we're adopting the rules that we adopt. So, you know, what we do want to do is have statewide uniform standards applicable to all operators in all jurisdictions. Part of our rules have come about because not all local governments have local regulations dealing with some of the issues that come up. Noise and odors, thank you, are some of those issues. Many local jurisdictions do, some don't, some that do don't enforce them. We get angry phone calls from the public. And if we don't have rules around that, we can't do anything about it. So some of our rules have evolved to fill a void or fill a perceived gap in local regulations. If that's the case, again, I promise you we would work very proactively with a local government to work those out. And then as I noted earlier, I do think we have a lot of experience and a lot of expertise. So I mentioned at the outset, I think there's cooperation than conflict. Some of the ways in which local governments have chosen to respond to concerns of their citizens, and believe me, there are a lot of concerned citizens out there, and I spend a fair amount of time talking to them as well. Some jurisdictions have adopted this memorandum of understanding or memorandum of agreement approach in which the local jurisdiction enters into an agreement with operators, either sort of globally for all the operators in their jurisdiction or operator by operator. So in order for an operator to get a permit from the county, or perhaps in order to get a more expedited permit, they ask the operator to agree to certain conditions that might go above and beyond our conditions. So an easy example is we just adopted a groundwater monitoring rule that requires an operator to monitor up to 4 water locations within a half a mile of their well. Let's say County X says, just go ahead and monitor all of the wells within a half a mile, all right? We would say a regulation in your ordinances that said that would be in conflict with ours, and that might lead to a lawsuit. But if you can get an agreement with the operator to do that, that's just fine with us. That's between the local jurisdiction and the operator, right? It's a contractual arrangement. We'll go one better than that, and we'll say if you can get that agreement with the operator, then have the operator tell us, hey, we're going to monitor all of the wells within a half mile, all right? That's now a condition of your state permit. And we will enforce that standard, all right? Our inspectors will inspect that. Our inspectors will enforce it if you're not doing it. So that's a route that several jurisdictions have opted to go. La Plata County actually has had sort of a precedent for that for many years. Erie adopted that kind of a program here, I don't know, 8 or 10 months ago. Arapahoe County just did a really good job of working very hard with us and with the operators in their jurisdiction to come up with that kind of agreement. Intergovernmental agreements on inspectors is another avenue that's been taken. Some jurisdictions are adopting a 2-track permitting system, so if you'll agree to these kinds of conditions that go above and beyond COGCC rules, we'll give you the administrative process, no public hearing, sort of a fast-track process on your county permit. If you don't want to agree to all those things, you go the other track, public hearing, you know, et cetera, et cetera. And I think that's a viable option. I'm running out of time. I have to talk about our local government designee program. The LGD program is, I introduce you to our LGLs, the counterpart at the county level, our local government designees. They're the person in your local government who is the point of contact for us, who gets permits from the operators when they submit permits to us. Those go to the local government designee. They're the person we hope knows and understands our rules. They're the person we hope calls us with questions, with concerns, that goes out into the community and meets with the citizens who have concerns. And the LGD program is good, getting better, growing. I think there are 52 county LGDs, 55 better, out of 64 counties with an LGD, and many, many, many municipalities and some special districts that have LGDs. A lot of people make, you know, one of their existing city or county staff members the LGD, better than not having one at all. But if it's just an add-on, you know, okay, fine. A few jurisdictions, La Plata and Garfield being 2 of them, have dedicated LGDs. That's their only job. And I'm scanning the room to find Kirby Wynn, and I finally did, blending into the wall back there. Kirby is dedicated LGD for Garfield County, does a great job, knows the operators, knows the citizens, and knows us, and knows our rules. And that is a formula for success. I'm going to stop there. Thank you very much. Happy to answer questions, of course, and I'll be around this afternoon if you want to find me as well.
Okay, well, let me introduce myself, John Baza. I'm the director of the Division of Oil, Gas, and Mining in Utah. And I do need to make a couple of corrections to your sheet of profiles that you have. First of all, the picture that's in there is kind of old. It's like 7 years old, and I think I've lost the mustache, my eyes have gone bad, and I've got a lot more gray hair now. So I'm going to have to tell my secretary stop sending a picture out. But also, it says I'm a doctor. I don't have a doctorate. I'm really not a doctor of anything. And I think I told someone yesterday the only thing I've ever tried to doctor is my wife's meatloaf, and I didn't try that more than once. I do want to introduce someone that I have with me. John Rogers is the head of our oil and gas program, and I'm going to show you a little bit how we're organized in the division so you can see where John fits into the organization chart. I really appreciate Rebecca's talk this morning and Matt's. I think it lays some great groundwork. And I know that you're all mostly interested in what's going on in Colorado. So here I am from Utah, and you're going to automatically start doing some comparisons. You know, what's the same as Colorado, what's different from Colorado. And I'm not going to try to point out the similarities and distinctions as much as just tell you who we are and maybe give you some ideas to why there are distinctions and why there are similarities. So let me just go ahead and proceed from there. We are part of a Department of Natural Resources, Division of Oil, Gas, and Mining. We are one of 7 divisions. We have 2 water divisions, Water Resources and Water Rights. We have our wildlife people. We have our state parks people. We have a geological survey, and we also have forestry, fire, and sovereign lands located in DNR. We are the agency that regulates the extractive industries in Utah as far as permitting and operational regulation. This is our division. We have 4 functional programs. We have a coal regulatory program, which is a federal primacy program. It comes out of the Office of Surface Mining. We have a non-coal or minerals program, which is a state program which gets its authority from state law, specifically the Utah Mineland Reclamation Act. And then an abandoned mine reclamation program, which also is federal. It's an adjunct to our coal regulatory program, also given to us from OSM. And we cannot have an abandoned mine program if we don't also have a coal regulatory program. So the 2 go hand in hand. And the objective there is it's more of a public works program to seal off hazards from old legacy mines in Utah. And then we have our oil and gas regulatory program, which is the one that John Rogers heads up. And we have a board of oil, gas, and mining. They are 7 members appointed by the governor. And they basically wear 2 hats. One is policy making, which they do through the creation and establishment of rules that we are forced to live by. But the other is they do a lot of adjudication, basic adjudication. Things like drilling and spacing units, things like unitization, approval of water floods, things like that. So we actually have formal hearings where the attorneys from various parties come and will provide their information, and our board has to render a decision on that. Similarly to COGCC, we have a governing statute that declares the public interest for why we exist. And I haven't provided the whole language up there, but the part I am providing indicates that we are to provide exclusive state authority over oil and gas exploration and development as regulated under the provisions of this chapter. Now that's interesting language, and just like Matt indicated, there's a lot of ambiguity in that. Because what does that really mean under the provisions of this chapter? Is it just oil and gas conservation? Does it stretch over into public health, safety, and welfare? Because when you look later on, the Board of Oil, Gas, and Mining has a lot of policy-making authority for the division. And so they're having to decide some of these things. And I feel like we're kind of a late player in the game. The demographics between Utah and Colorado have some similarities. Colorado has more population than we do. Colorado has more oil and gas development than we do. So I think there's a whole lot more legal analysis and case law, even in Colorado, than exists in Utah. And so we're still struggling with what some of these things mean that are given to us in our statute. But here's how we have tried to posture ourselves in the state of Utah. We view ourselves as an upstream agency, meaning that we're looking at things like site construction and reclamation, drilling, production, mining, some of the basic milling and separation processes, and pre-sales processing of commodities. And then when you cross the line into downstream, that's where we don't have any activity or business. We don't deal with transportation per se. We don't deal with refining and separation for market. And we don't deal with distribution and consumer sales. Yet, every time the price of gasoline goes up at the pump, I have people calling me about every day saying, well, what are you guys at the state doing about this gas price? I can't really help you with that, sir, but let me try to put you in contact with people who may have more understanding of that than I Let me give you a little bit of petroleum history in Utah, and this is where you may start drawing some comparisons and distinctions with Colorado. First oil well drilled in Utah was in Grand County in 1891. Grand County stretches from the Utah-Colorado border more towards the central area of the state, and you cross the northern part of it as you're going on I-70. But that's where the first oil well in the state was drilled, is in Grand County. The first gas well, or gas field, was located in Davis County, which is a little county just north of Salt Lake City. And the whole idea there was in the 1890s, they were extracting gas from some shallow methane fields in the Farmington Bay area and piping it into Salt Lake City to use in street lamps at the turn of the century. But it took clear until 1950 before there was any kind of oil and gas or conservation principles that were being looked at in the state. And as Matt pointed out with Spindletop in Texas, those conservation principles were based on, gosh, how do we prevent the waste of this valuable commodity? So initial oil and gas conservation responsibilities were placed with our state land board in 1950. But that was principally to ensure that the state was getting its fair share of revenue from wells drilled on their land. As petroleum commercialization expanded, and especially with the growth of the Anna Field in the Four Corners area, the Utah Oil and Gas Conservation Commission was created in 1955 as a separate entity of state government. Then in 1968, the Department of Natural Resources was created. That's the diagram I showed you at the very beginning. And that's when we were folded in with all of these other state agencies. We were still the Division of Oil and Gas Conservation at the time, but now we were a part of a larger department. And then in 1975, I mentioned this Utah Mine Land Reclamation Act. That came into being in the state. That created our non-coal minerals regulatory program. And that's when the name of the agency changed to Division of Oil, Gas, and Mining. And that name is now stuck for these many years. So what is our mission today? Well, we regulate and ensure industry compliance and site restoration while facilitating oil, gas, and mining activities. Now that facilitation part is pretty important because, you know, we have struggled with the perception that our agency has for many years. There are members of the public who don't think we're regulating enough. There are members of industry who think we're regulating too much. But we do feel that part of our job is to facilitate development because the legislature said these are valuable commodities that need to be produced. So let's figure out a way to produce them. But our governing values are that we expect responsible development and reclamation of lands. We are trying to protect the correlative rights of the mineral estate to ensure that everybody's getting their fair share of produced revenue. We're trying to prevent the waste of resources, and we're trying to protect human health and safety, the environment, and other interests of the state, which means collaborating with many other agencies of state government. There's a complication in Utah, and this map is going to highlight some of that. The complication is we have this diverse mix of land types, and you'll notice all of the yellow that's there. That is BLM managed land in Utah. That's a sizable chunk of the state. So when I posed the question to Rebecca earlier, it's, you know, we have to learn to get along with our federal counterparts. And I know that there's a lot of I guess, pushback in our legislature right now, trying to figure out, well, how can we increase the expectation on the federal government beyond what it's been traditionally in Utah? But this is a complication because the amount of land that we have exclusive jurisdiction over where there's not a federal agency is frankly pretty small. And that's depicted by this set of statistics that the BLM produces every year. You can see the western states, are listed over there. And what I've done is I've ranked the states according to the percentage of federal land as compared to their land mass that exists. So the second column shows the amount of land total in each state, and then the federal mineral percentage that exists. Well, the top 10 states go all the way down to Colorado. Beyond that, those states listed really have such relatively low percentages of federal land that they wouldn't even show up on the same bar chart. But you can see up at the top, we've got Nevada at 83%, Idaho at 69%, and then you've got Utah coming in at 66.8. 2/3 of our land area is federal minerals. And frankly, going down that list of top 3, we're the first state that is on the list that has significant oil and gas resources. So it says that, gosh, we've got to figure out how we're going to interact with the federal government. I know that you guys are more interested in local and state interaction, but we have the same problem when we look up at the feds. You know, how do we get the feds to recognize our voice and collaborate with us more in what we're doing? These charts didn't show up on the transfer of data very well. But what I'm trying to do is just show you some statistics that depict how Utah's petroleum industry has changed pretty dramatically over the last 20 and 30 years. Is there a laser on this? Does anyone know? Okay, so if you look at some of these numbers, these are the number of approvals of applications to drill that we have approved over the years. And you can see, and it's hard to tell, but this chart goes back to about 1984, 85. So through the 80s and much of the 90s, we hovered below 500 applications approved on a yearly basis. Now, I wasn't working for the division back in the 90s, but if someone had told me that Utah was ever going to exceed 2,000 approvals to drill in a year, I would have laughed at it. But then if we come here in 2008 or 2006 maybe, can't remember which year that is, but one of those years we did exceed 2,000 APDs approved. And it tapered off a little bit and we thought, wow, weathered that storm. But boom, 2012, we come right back up and we've approved over 2,100 applications to drill. So the petroleum business is vibrant and active and busy in Utah. Not to the extent that's going on in Colorado. But, for Utah, it's pretty darn good. This is historical oil production, and this one goes back to about 1975. But you can see that the chart has been up here in the very high numbers, up close to 40 million barrels of oil produced in a year back in the mid-1980s. And then it just started dropping off. So about the mid-1990s, it hit a low of about 1 million barrels of oil a year. No, excuse me, 10 million. And now it's ramped up in the past few years. And this is our liquids production. So this last year, we were approaching 30 million barrels of oil that were produced in the state. This is our gas production. Similarly, it's gone up and down over the years. But what's interesting about this is this number, and this is 2012 again, is a record high for the state of Utah, historically high. So we're rapidly becoming a big player in the natural gas production industry. So the petroleum landscape in Utah is dynamically shifting. Things are happening quickly. Activity is booming as far as Utah goes. But we're starting to see the movement of the oil patch towards more cultivated land and residential property, which creates its own set of conflicts. We're seeing increasing environmental pressure from government agencies, the public, NGOs regarding air, water, and sensitive species. So all of these things are things we're being forced to address now. Some issues raised recently, differences in permitting processing times between state and federal agencies. It's interesting, I mean, we pride ourselves on getting APDs out within a 30 to 45-day window. And yet, if you were to walk into the VLM Vernal District office today and submit an application to drill, you're looking at about 18 months to get an approval on that APD. And it's just a backlog that exists out there. So industry constantly puts pressure on us and says, well, what can you guys do about it? Well, you know, can't get the feds to turn stuff over to us. So, we do have issues with split estate that have risen fairly rapidly and increasingly in the last 5 years. We too have county versus state jurisdictional discussions over setback requirements. We're doing a lot of planning for sage grouse, hydraulic fracturing regulations. I mentioned the legislative push against federal land control. And we've also got Native American lands in Utah that we have to be collaborative with those tribal nations. So what recently have we done in order to address some of this stuff? Well, we put a new hydraulic fracturing rule in place, our board did, effective November 1st of last year. It doesn't go nearly as far as what Colorado did, but I'll kind of show you how that works in a minute. We have a new surface owner protection rule that was effective January 23rd of this year, which was a function of a statutory change by the legislature. Our board is currently considering updates to waste management and disposal. Those will probably be effective sometime this summer. And finally, the board has instructed the division to brief them later on this year regarding the setback requirements for oil and gas wells from residential and other structures. The reason is because you saw the Duchesne County Commissioners here yesterday. They recently established an ordinance for setbacks within their county that has created a lot of debate and discussion. So our board is saying, well, if we need to do something about this, give us some advice on what other states are doing. And so we'll be reporting back to our board probably by the end of the summer on that issue. This is what happened with our hydraulic fracturing rule. Frankly, the only new change that occurred because of the rule was a chemical disclosure requirement that is now mandatory. Previously, it was voluntary, and that's using the Frac Focus software. But what we also tried to do is affirm with the remainder of that rule that there are existing rules pertaining to well-designed architecture and integrity. Those rules were in place and are still in place as part of the hydraulic fracturing rule set. This is our website. I encourage you to go to it. You'll see various icons there that show our programs. The little pump jack is oil and gas. And if you were to click on that, you would get to our oil and gas website, which we're pretty proud of. We have an excellent electronic processing feature that allows operators to both report and apply for permits online. And that's the extent of my presentation. I would offer my regrets and apologies, but I will not be around later for one-on-one meetings. I have to get back to Salt Lake and make a quick turnaround for another out-of-town trip. But I'll be around at least for the next 30 minutes or so and be able to answer questions during that time.
Elbert County has a question. I don't believe it.
I know. They say my tongue wags at both ends. Matt, on the inspectors, you mentioned that the state legislature has just approved, I think, some additional inspectors, and clearly that's good, but there's also been some talk, and maybe Nancy could help too, about the possibility of local inspectors from the county, either on a volunteer basis or people that we would contract with or hire, that would be trained by this GOCC and be authorized to do our own on-site inspections within the county. Can you comment on that just a little bit? Is that still on the table?
Yeah, it is on, okay, great. So the statute authorizes us to delegate our inspection authority to other jurisdictions, and we have done that with Gunnison County. We were very, very involved in the hiring and training of that Gunnison County attorney, and he really functions as one of our inspectors, but he is dedicated to Gunnison County and he's paid by Gunnison County. He's using a state-issued computer that has access to our database, so in that sense, he's one of us. Any jurisdiction that wants to do that can do that. An issue that arose with Gunnison is our inspectors inspect about 1,000 wells a year, and that's kind of the expectation. I think Gunnison County has like 19 or 20 wells. It's not a full-time job, and that made it difficult for them to hire someone. And I think, you know, Elbert County, which doesn't have a whole lot of activity right now, almost any other jurisdiction except perhaps Weld and maybe Garfield. I think, you know, I would encourage you to think about, can we partner with some of the surrounding local governments and jurisdictions and say, between us, we have enough, you know, we sort of have a critical mass that would make sense to have an inspector for this area.
Anyone else?
With respect to the Utah service rights owners, what does that new legislation do for service rights owners?
It was a harshly debated bill, let me tell you that. I think initially it came out and it had some what I call very strict covenants in terms of how state or surface owners would insert themselves into the application process for drilling, how they could basically have some rights in negotiating with mineral owners. But as you can imagine, at least in Utah, the mineral estate is still considered dominant, and the industry was very, very vocal about retaining that long-held mineral estate right. So when the bill finally came out, it was a bit watered down, and what it did was it created an ability for the Division of Oil, Gas, and Mining to bond on in split estate situations so that the mineral owner and the surface owner could go through a negotiation process with some mediation. And we actually were required through the Department of Agriculture and us to develop a list of certified mediators that as they bonded, as they went through this mediation process, then the company could go forward with their plans to drill the well, knowing that depending on the outcome of the mediation process, that bond could be forfeited if it turned out that the landowner was severely impacted by the drilling of that well. So that's what the rules basically allow for right now, is that bonding process and the ability to mediate.
Any other questions? I don't know.
In every one of the presentations, I've seen we really want to address the environmental, conservation, wildlife, imperiled species, et cetera, concerns. But it always comes at the end that during this process, we're going to be concerned about this. Does anyone discuss the potential for a discussion to happen at the very beginning, before the approvals are given, before the activity begins to occur, to have the discussion about what are the environmental concerns, what are the wildlife concerns. So it isn't only at the end where you're saying, oh yes, we better consider that cutthroat trout that's an endangered species. We seem to do it at the end rather than have the discussion at the beginning. Is there any talk about having a discussion at the beginning to know what those issues are going to be?
Well, let me start with wildlife. In Colorado, if your proposed oil and gas location is in either what we call a sensitive wildlife habitat or a restricted surface occupancy area, you will have to have a consultation with the Colorado Parks Division of Wildlife about whether that location is the right location and whether there should be restrictions placed on that location based on the wildlife impacts. And Rebecca alluded to some of the stipulations in federal permits. In the state permits, we call them conditions of approval, and they would be similar to the kinds of things that she mentioned, timing restrictions and so forth. And so it's very much concerned with the impacts to the habitat, breaking up habitat, things like that, not having operations ongoing during mating season or migration season and so forth. All of that happens at the front end. So for us, an operator comes in and makes an application for a permit to drill. They have to get two permits, really. They have to get a location assessment permit and a drilling permit. And the location assessment process is all about the surface and the appropriateness of that location for oil and gas, its impacts on the environment, its impacts on wildlife. So I would tell you that those things are very much built into the front end of our process. And that's separate from or in conjunction with regulations that limit emissions, regulations that control lining of pits and other things that are intended to mitigate environmental impacts. And the setback rulemaking process, we say setbacks that we just went through, fairly contentious for about 4 months. Much of that was concerned with mitigating impacts from drilling to the environment in sort of in a broader sense, by which I mean including noise issues and light issues and things like that. But some of those were related to the environment. So requiring green completion so that we're not venting methane into the air, so that we put infrastructure in place before we turn the well on.